We on chapter 9 of bailment. 148 bailment. Excuse me. Bailment, bailor, and bailee defined. A bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned and otherwise disposed of according to the direction of the person delivering them. The person delivering the goods is called the bailor. The person to whom they are delivered is called the bailee. Explanation: if a person already in possession of the goods of other contracts hold them as a bailee, he thereby becomes the bailee, and the owner becomes the bailor of such goods, although they may not have been delivered by way of bailment. 149. Delivery to bailee, how made. The delivery to be bailee may be the delivery to the delivery to the bailee may be made by doing anything which has the effect of putting the goods in the possession of the intended bailee or of any person authorized to hold them on his behalf. (150) Bailor's duty to disclose faults in goods bailed. The bailor is bound to disclose to the bailee faults in the goods bailed, of which the bailor is aware, and which materially interfere with this use of them, or expose the bailee to extraordinary risk. And if he does not make such disclosure, he is responsible for damage arising to the bailee directly from such faults. 151. Care to be taken by bailee. In all cases of bailment, the bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would. Under similar circumstances, take of his own goods of the same bulk, quality, and value as the goods bailed. Take of his own goods of the same bulk, quality, and value as the goods bailed. 152. Bailee when not liable for loss, etc., of things bailed. The bailee, in the absence of any special contract, is not responsible for the loss, destruction, or deterioration of the thing bailed, if he has taken the amount of care of it described in section 151. (153) Termination of bailment by bailee's act inconsistent with conditions. A contract of bailment is voidable at the option of the bailor. If the bailee does any act with regard to the foods bailed inconsistent with the conditions of the bailment. 154. Liability of bailee making unauthorized use of goods bailed. If the bailee makes any use of the goods bailed which is not according to the conditions of the bailment, he is liable to make compensation to the bailor for any damage arising to the goods from or during such use of them. 151. 155. Effect of mixture with bailor's consent of his goods with bailee's. If the bailee, with the consent of the bailor, mixes the goods of the bailor with his own goods, the bailor and the bailee shall have an interest in proportion to their respective shares in the mixture thus produced. 156. Effect of mixture without bailor's consent. When the goods can be separated. If the bailee, without the consent of the bailor, mixes the goods of the bailor with his own goods, and the goods can be separated or divided, the property in the goods remains in the parties respectively, but the bailee is bound to bear the expense of separation or division and any damage arising from the mixture. 157. Effect of mixture without bailor's consent when the goods cannot be separated. If the bailee, without the consent of the bailor, mixes the fruits of the bailor with his own goods in such a manner that it is impossible to separate the goods bailed from the other goods, to deliver them back, the bailor is entitled to be compensated by the bailee for the loss of the goods. 158. This is a good one right here. If the bailee, without the consent of the bailor, mixes the foods of the bailor with his own goods in such a manner that it is impossible to separate the goods bailed from the other goods and deliver them back, the bailor is entitled to be compensated by the bailor for the loss of the good. 158. Repayment by bailor of necessary expenses, where by the conditions of the bailment the goods are to be kept, or to be carried, or to have work done upon them by the bailee for the bailor, and the bailee is to receive no remuneration, the bailors shall repay to the bailee the necessary expenses incurred by him for the purpose of the bailment. 159. Restoration of goods lent gratuitously. The lender of a thing for use may at any time require its return if the loan was gratuitous, even though he lent it for a specified time or purpose, but if on the faith of such loan made for a specified time or purpose, the borrower has acted in such a manner that the return of the thing lent before the time agreed upon would cause him losses exceeding the benefit actually derived by him from the loan, the lender must, if he compels the return, indemnify the borrower for the amount in which the loss occasion exceeds the benefit so derived. The lender of a thing for use may at any time its return, if the loan was gratuitous, even though he lent it for a specified time and purpose, but if on the faith of such loan made by a specified time or purpose, the borrower has acted in such a manner that the return of the thing lent before the time agreed upon would cause him losses exceeding the benefit actually derived by him from the loan, The lender must, if he compels the return, indemnify the borrower for the amount in which the loss so occasioned exceeds the benefit so derived. He must, if he compels the return, indemnify the borrower for the amount in which the loss so occasioned exceeds the benefit so derived. So, 160, return of goods bailed on expiration of time or accomplishment of purpose. The return of goods bailed on expiration of time or accomplishment of purpose. It is the duty of the bailee to return or deliver according to the bailor's directions the goods bailed without demand as soon as the time for which they were bailed has expired and the purpose for which they were bailed has been accomplished. It is the duty of the bailee to return or deliver according to the bailor's directions. It is the duty of the bailee to return or deliver according to the bailor's directions the goods bailed without demand as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. 161. Bailee's responsibility when goods are not duly returned. If by the fault of the bailee the goods are not returned, delivered, or tendered at the proper time, he is responsible to the bailor for any loss, destruction, or deterioration of the goods from that time. 162. Termination of gratuitous bailment by death. A gratuitous bailment is terminated by the death either of the bailor or of the bailee. 163. Bailor entitled to increase or profit from goods bailed. In the absence of any contract to the contrary, the bailee is bound to deliver to the bailor or according to his directions any increase or profit which may have occurred from the goods bailed. 164. Bailor responsibility to bailee. The bailor is responsible to the bailee for any loss which the bailee may sustain the reason that the bailor was not entitled to make the bailment or to receive back the goods or to give directions respecting them. 164. Bailor's responsibility to bailee. The bailor is responsible to the bailee for any loss which the bailee may sustain the reason that the bailor was not entitled to make the bailment or to receive back the goods or to give direction respecting them. 165. Bailment by several joint owners. If several joint owners of goods bail them, the bailee may deliver them back to or according to the directions of one joint owner without the consent of all in the absence of any agreement to the contrary. One joint owner without the consent of all in the absence of any agreement to the contrary. If several joint owners of goods bail them, If several joint owners of goods bail them, the bailee may deliver them back to or according to the directions of one joint owner without the consent of all, in the absence of any agreement to the contrary. 166. Bailee not responsible on redelivery to bailer without title. 166. Bailee not responsible on delivery to bailer without title. If the bailer has no title to the goods and the bailee in good faith delivers them back to or according to the directions of the bailer, the bailee is not responsible to the owner in respect of such delivery. If the bailer has no title to the goods and the bailee in good faith delivers them back to or according to the directions of the bailer, the bailee is not responsible to the owner in respect of such delivery. One more time for me. My mind's somewhere else. Excuse me, too. If the bailer has no title to the goods and the bailee in good faith delivers them back to or according to the directions of the bailer, the bailee is not responsible to the owner in respect of such delivery. 167. Right of third person claiming goods bail. If a person other than the bailer claims goods bailed, he may apply to the court to stop delivery of the goods to the bailer and to decide the title of the goods. 168. Right to finder of goods may sue for a specified reward offered. Right to finder of goods may sue for a specified reward offered. The finder of goods has no right to use the owner for compensation for trouble and expense voluntary incurred by him to preserve the goods and to find out the owner, but he may retain the goods again, the owner, until he receive such compensation. And where the owner has offered a specific required for the return of goods lost, the finder may sue for such reward and may retain the goods until he receive it. I'm going to read that one over too since I'm broke. The finder of goods has no right to use the owner for compensation for trouble and expense voluntary incurred by him to preserve the goods and find out the owner, but he may return the goods again, the owner, until he receives such compensation, and where the owner has offered a specific required for the goods of goods lost, the finder may sue for such reward and may retain the goods until he receive it. 169. When finder of thing commonly on sale may sell it. When finder of thing commonly on sale may sell it. When thing which is commonly the subject of sale is lost, if the owner cannot without reasonable diligence be found, or if he refuses upon demand to pay the lawful charges of the finder may sell it. 1. When the thing is in danger of perishing or of losing the greater part of its value. 2. When the lawful charges of the finder in respect of the thing found amount to 2/3 of its value. 170. Bailee's particular lien. Where the bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of the contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. 171. General lien of bankers, factors, warfinger, attorneys, and policy brokers. Bankers, factor, warfingers, attorneys of a high court, and policy brokers may, in the absence of a contract to the contrary, retain as a security for a general balance of account any goods bailed to them, but no other person have a right retained as a security for which balance goods bailed to them unless is an express contract to that effect. 172. Pledge, pawner, and pawnee defined. The bailment of goods as security for payment of a debt, performance of a debt or performance of a promise is called pledge. Excuse me. The bailment of goods as security for payment of a debt or performance of a purpose is called a pledge. The bailor, in this case called pawner, the bailee is called the pawnee. 173. Pawnee's right to retain. The pawnee may retain the goods pledged not only for payment of the debt or the performance of the promise, but for the interests of the debt and all necessary expenses incurred by him in respect to the possession or for the preservation of the goods pledged. Boy, where my head at? Kibido. The pawnee may retain the goods pledged not only for payment of the pledge or the performance of the promise, but for the interests of the debt and all necessary expenses incurred by him in respect to the possession or for the preservation of the goods pledged. 174. Pawnee not to retain for debt or promise other than for which goods pledged. Presumption in case of subsequent advances. The pawnee shall not, in the absence of a contract to that effect, retain the goods pledged for any debt or promise of other than the debt promise for which they are pledged, with such contract, in the absence of anything to the contrary, shall be presumed in regard to subsequent advances made by the pawnee. 175. Pawnee's right as to extraordinary expenses incurred. The pawnee is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of the goods pledged. 176. Pawnee's rights where pawner make default. If the pawner makes default in payment of the debt or performance at the stipulated time or the promise in respect of which the goods were pledged, the pawnee may bring as suit against the pawner upon the debt or promise and retain the goods pledged as a collateral security, or he may sell the thing pledged on giving the pawner reasonable notice of the sale. If the proceeds of such sale are less than the amount due in respect of the debt or promise, the pawner is still liable to pay the balance. If the proceeds of the sale are greater than the amount so due, the pawnee shall pay over a surplus to the pawner. 177. Defaulting pawner right to redeem. And the time is stipulated for the payment of the debt or performance of the promise for which the pledge is made, and the pawnee makes default in payment of the debt or performance for the promise at a stipulated time, he may redeem the goods pledged at any subsequent time before the actual sale of them, but he must, on that case, pay in addition any expenses which has arisen from his default. 178, pledged by mercantile agent. Let's go. Where a mercantile agent is, with the consent of the owner, in possession of goods or the documents of title to goods, any pledge made by him when acting in the ordinary course of business of the mercantile agent shall be as valid as he were expressly authorized by the owner of the goods to make the same, provided that the pawnee acts in good faith and has not, at the time of the pledge, noticed that the pawnee has not authority to pledge. Explanation. In this section, the expression mercantile agent and document of title shall have the meanings assigned to them in the Indian Sales of Goods Act 1933 of 1930. 178A, pledged by person in possession under voidable contract. When the pawnee has obtained possession of the other goods pledged by him under the contract, voidable under Section 19 of Section 19A, but the contract has not been rescinded at the time of the pledge, the pawnee acquired the goods title to the goods, provided he acts in good faith and without notice of the pawnee's defect of title. All in good faith and with clean hands. Sound right, conscious, and with good reason, for good reason, for good reason. 179, pledge where pawnee has only a limited interest, where person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that interest. 180, suit by bailor or bailee against wrongdoer. If the third person wrongfully deprives the bailee of the use of possession of goods bailed or does them any injury, the bailee is entitled to use such remedies as the owner might have used in the like case if no bailment has been made, and either the bailor or the bailee may bring a suit against the third person for such deprivation or injury. 181, appointment of relief or compensation obtained by such suit. Whatever is obtained by way of relief of compensation in any such suit shall, as between the bailor and the bailee, be dealt with according to their respective interests. Sis. And we at 10, man. We almost done. Peace.